So, after Young Thug has been freed, the last two remaining people are Shannon and Yak. And let's watch and react right now. This is Viral News Source, where we bring you the hottest news all of the time and we react to it. Let's go.
Right, marijuana.
Marijuana, which carries a sentence of 1 to 10 years. As to count 59, I believe that's the possession of codeine with the intent to distribute, which is 1 to 5, which is 5 to 30 years, and count 59, which is the possession of cocaine, which
That
is
60 is possession of cocaine.
so 59 was the codeine, 60
Right.
is the possession of cocaine, which was
Wow.
1 to 5 years. Possession of a firearm during the commission of a felony, which was count 61, which is 5
Wow.
years to serve consecutive to any count indictment. Possession of a machine gun, which was count 62, which was 10 years to serve consecutive. And then he was charged with count 63, which is possession of a firearm by a convicted felon pursuant to 1611-133. I know my math isn't the best, but that's life plus some years. The state's recommendation, Your Honor, was for Mr. Kendrick to plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which was 20 to serve 15. Count 2, the murder reduced to voluntary manslaughter, 20 years to serve 15. Excuse me, 20 years to serve 15. And then to the gang
That's
count.
30.
Count
57.
57, also 20 years to serve 15, all to more concurrent, and the state was willing to null pros all the other counts in the indictment.
All right. And
So that would be
Mr.
15.
Kendrick and the attorneys associated with you. I want to make sure that y'all know that unlike what happened.
And I think the murder charges, because I don't think Thug was hit with a murder charge. But these guys have, and that kind of changes the situation. Let's hear what the judge has to say.
And with Mr. Williams, if you plead non-negotiated to less than all of the charges, there is nothing that the court can do if the state chooses to go forward with some of those charges. So you could not do what Mr. Williams pled guilty or nolo to each of the charges that he was facing. You cannot say, well, I'd like to plead guilty to count 1 and I'd like to plead to the reduced charge on count 2. And then I'd like to just skip the rest of them, because the state can say, well, we're not skipping the rest of them. We're still going to try you for the rest of them. And the state can also say, we're not okay with letting you plead to voluntary manslaughter unless you abide by the terms of the agreement. We're going to go forward with the murder trial. So I know that Mr. Weinstein, you and Mr. Apt and everybody else who's been helping know that, but because things seem to have worked out sort of beneficially for some of these other people who have already pled, y'all might think, oh, well, gosh, can't we do something better than that? Given what you're facing, they hold a lot of the cards, and a lot of it is outside.
Yeah, so once you start introducing murder, like these guys are being charged with murder, like directly, that changes the game. Let's listen.
Of the ability of this court to change. Okay. All right.
We understand that, Your Honor. Thank you for advising us of that.
All right. Mr. Stillwell is facing.
Your Honor, Mr. Stillwell is also looking at count 1, which the conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which is 5 to 20 years. He is facing 2 counts of murder for count 2 and count 49, which each carries a sentence of life imprisonment. He's also charged with count 50 of this indictment, Your Honor, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He's also charged
Man, fighting two murders, two bodies, that right there, my friend, you've got big problems.
With count 51, participation in criminal street gang activity, also a sentence of 5 to 20 years. Count 52, possession of a firearm by a convicted felon, previously convicted under 1611-133, which is 15 years consecutive to any count in the indictment. 54, possession of a firearm during the commission of a felony, which is 5 years to serve consecutive. Count 64, which is another possession of a firearm by a convicted felon under 1611-133, which is also 15 years to serve consecutive. So
Wow.
Mr. Stillwell's looking at maximum of 2 life sentences plus
85 years.
plus 85 years, Your Honor. The state's recommendation, and I'll just say globally, Your Honor, was 60 years to serve 40 years in prison, that we would have reduced both of the murders to voluntary manslaughter, Your Honor. And we had given his attorney the option to kind of craft how that 40 years would look. But that was the extent to our negotiations, Your Honor.
And Mr. Stillwell, kind of the same information to you. If the state does not want to reduce charges, you're not entitled to plead to reduce charges. They can say, you got to face these murder charges and we're going to make it a jury trial if you don't agree to what we're offering. Same thing, you can't say.
But you know what, though, at this point, if I were him, and if they won't reduce, like, if they don't give him a deal, or both of those guys a deal like Thug got or similar, I would take my chances with the trial. And the reason why, we already know the judge feels like the prosecution is sloppy. And she had to fix their sloppiness, and evidently she couldn't get it fixed because Thug is out of there. Right? And the other guys had plea deals. Now, one guy had a life sentence already, and then he came back, and then he had his other murder charge like thrown out, or whatever the charge was. The young guy, little somebody. But anyway, yeah, if I were these guys, if they don't have a better offer, one that gets them free like now, I would go to trial, see how it goes.
I'd like those other charges dismissed if they're not willing to dismiss them in exchange for the negotiated sentence. So obviously each of you has the right to continue with the trial. You know, what you're doing, you are all have very capable attorneys representing you, who clearly care very passionately about you all personally, as well as presenting your best case. But it's ultimately going to be up to the jury, and you cannot know what any jury is going to do. And they may say, I don't believe a single bit of this beyond a reasonable doubt. Y'all are both walking. They may say, you know what, I buy this, I don't buy that. I'm convicting you of 4 of the 5 or 4 of the 8 charges. You're still then going to face sentencing. They may convict you of everything. And if you are convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to 40 years to serve with parole as a possibility. And Mr. Kendrick, you are facing life plus, I think I added up 115 years instead of 20 to serve 15. So it's just something to think about. And I mean, it's already past 5 o'clock. So are y'all going to leave the offer open until you have withdrawn the offer before you even put it on the record to?
We communicated this to them last night, but they did not accept it.
All right, well, given that the state spent the entire day negotiating Mr. Williams' plea, ultimately unsuccessfully. I don't know if either Mr. Weinstein or Mr. Sharp would have been able to negotiate with you during today.
They would have, no one, we didn't have any communication from Mr. Weinstein or Mr. And they rejected the offer.
Okay.
I did have communication with Mr. Abate today. I attempted to have communications with the DA last Tuesday morning, but she failed to show up for our meeting.
Any chance y'all might leave it open until 9 o'clock tomorrow?
Your Honor, I'll consult with the DA and if she wishes to read.
Okay. I mean, I have no idea whether they'd want to keep it, but I haven't, we haven't put it on the record and I haven't ensured myself as the court that they understood what the potential sentences were up until just now. So I would appreciate it if she would, so that they have the opportunity, having heard from the court, to talk to their attorneys. And they may still say that we're good, we're going forward, but.
We'll consult with the attorney, but as a.
Okay. So in the event that it is no longer open to you or that you decide to reject it anyway, I plan to start the trial again Monday morning. I'm going to have the jury be here at 9. I'm going to have us be here at 8:30. We're back to getting no sleep. So I'll see y'all at 8:30 regardless. Okay, now court is adjourned.